My name is Samantha Lyons. I am an elder law attorney at Enea, Scanlan and Sirignano. In regards to protecting your assets, we also are going to just briefly discuss some of the estate planning basics. So, if you haven't attended the earlier programs, this is not going to be repetitive. So again, welcome, lots of information. I'm more than happy to circulate my slides at the end, so don't worry about jotting down all of the information. But let's start with kind of the documents that are highly recommended. A lot of times there is, I'd say, a stigma or misconception that if you are not very wealthy, you don't need any type of estate planning. That's not true. I really would highly recommend these first batch of documents known as advanced directives to anyone over the age of 18, really not taking into account your assets or your income. They're just very important documents. Last will and testament is a great document to have. It doesn't necessarily protect your assets from the cost of long-term care, but we're going to discuss kind of the benefits of doing trusts to protect assets, which is the revocable and the irrevocable trust versus the last will and testament. So a healthcare proxy. You may have heard of this type of document before. You may have seen kind of a more boilerplate form, whether it be through your doctor's office or maybe you or a loved one had a surgery or a procedure and they kind of brought you to the form to the bed. It's basically a document that allows you to decide who will make healthcare decisions for you if you are unwilling or unable to. So God forbid you became incapacitated and you're not able to have a conversation with a doctor or a provider as to what your wishes are. We want to make sure you, when of sound mind, have put in writing who you want to be able to basically step into your shoes and make those decisions. You're going to want to appoint someone that you trust, right? You want to be able to have that conversation, which may be uncomfortable, but is very important to have as to all of your wishes. In regards to organ donation, tube feeding, ventilation, we really highly encourage that the person you've appointed as your proxy, you are going to have this open and honest conversation with. So if they ever need to step into your shoes in a medical crisis, potentially, they're aware of what it is that you would want. You can only appoint one person at a time. A doctor or a hospital is not going to want to look to two people because unfortunately, especially in times of crisis, things may get a little stressful, right? And we may have two people who recall a conversation differently and want to honor a loved one's wishes differently. So you only can appoint one person. You can have a scheme. Basically, I appoint my husband. If not my husband, then my brother. If not my brother, then my friend. You can continue to go down the line, but it has to be one at a time. If you do not have a healthcare proxy and you, God forbid, became incapacitated, we're going to be looking to what's called the Family Medical Decision-Making Act, which is basically a next of kin scheme as to who's going to be able to make medical decisions for you. So very important if, let's say, we have clients sometimes where they may still be legally married, but separated, and they don't want that spouse to be able to make medical decisions for them. They are, basically the one that the hospital would turn to, absent a directive otherwise. So if that were to be your situation, again, very important you put in writing who is the individual you want to make those medical decisions. A HIPAA form, just briefly, that is a form you've probably filled out, definitely have seen one. It's for the release of health information, so your confidential medical records, if you've ever requested something from your doctor's office, a hospital, nursing home, etc., they're going to ask you to fill out a HIPAA form. Living will. So again, I don't mean to breeze through these, but these are kind of the basic documents that are going to lay the foundation for the asset protection planning. A living will is discussing your end of life decision making. So it's basically a document that while you are of sound mind, you are signing, stating that if God forbid you are in a permanently unconscious, comatose vegetative state, no hope of recovery, you don't want to be kept alive by extraordinary measures. This is the conversation you would have had with your healthcare proxy, and they kind of are going to have this in their back pocket. Should they, God forbid, after have to make that decision and have that discussion with a doctor, the doctor is going to ask, has there been a DNR, or do not resuscitate, a living will, or something called a MOLST form. So living will is not the same as a DNR. It's not going to apply across the board. It's not stating, God forbid, your heart stops, you don't want to be resuscitated, but is reviewing if you are in that permanently unconscious, vegetative, comatose, no brain activity, no chance of recovery. You don't want to be kept alive by heroic or extraordinary measures. Power of attorney. So if you take nothing away from today's presentation, I would hope that you take that a durable power of attorney is a very important document that all of you should have. Again, anyone over the age of 18 should have a discussion and do a durable power of attorney. We've been discussing healthcare decision-making. This is now transitioning us into financial decisions. A durable power of attorney allows you to appoint an individual or numerous people. So the difference between this and the healthcare proxy is you can appoint more than one person to handle financial affairs on your behalf. So you're going to look to somebody that you trust, whether it be a friend, a loved one. Some people use corporate, what's called fiduciary. So they utilize a bank to act as the agent, or certain organizations. Without a valid power of attorney, if God forbid you become incapacitated, if you have assets in your name alone, whether it be checking, savings, life insurance, retirement accounts, real property, nobody has the access to sell, transfer, give away those assets without a valid power of attorney. We're going to be discussing what is called an Article 81 guardianship proceeding, which is where someone is going to be petitioning the court on your behalf to have you determined to be an incapacitated individual and have a guardian be appointed on your behalf to handle either personal matters, whether that be healthcare decisions, choosing where you reside, or financial decision making. We can avoid going to court, which is stressful, time consuming, expensive with legal fees, by having a power of attorney. In New York, we have a statutory short form. So that form actually just changed June 13th of last year. So if you've done a power of attorney within, let's call it the past year, as of June 13, 2021 to now, you want to make sure that it was done on the proper statutory form. The form prior to this most recent change was a 2010 form. If you were to execute the old form today, it would not be a valid power of attorney. So very important, people will ask, well, is it required that I use an attorney to do these documents? Not necessarily. It is, again, a statutory form. But if you were to obtain the form from, let's say, a title company, it's going to be the very basic statutory framework. The form that we utilize, we've added a lot of provisions. I think it's about 6 or 7 additional pages that the statutory form does not include under modifications. So once this power of attorney, especially the one that our firm utilizes, is fully executed, so all recommended spots have been initialed, it's been signed in front of the notary and 2 witnesses, the agent, the person you've appointed, has broad power to transfer assets and help engage in asset preservation. So this is, again, if you cannot make these decisions, you cannot sign the documents, you've appointed someone to be able to step into your shoes now in your financial decisions. Some individuals and clients of ours are, uncomfortable with very broad gifting powers, meaning giving somebody, whether it be their spouse, their child, a friend, the discretion to move any and all assets out of their name. So those powers can be customized based on really your comfort level as what's called the principal. The principal is the person who is signing that power of attorney. The general provisions, pretty much we want to cover any and all financial decisions that you would handle personally. We want the agent to be able to do on your behalf, right? We discussed the potential for an Article 81 guardianship proceeding should you become incapacitated. Well, if you've done a power of attorney, but you've really limited what the agent can do, unfortunately, they may be having that same conversation with an attorney down the line, should you become incapacitated, to petition the court to get authority to do something that the power of attorney did not. So very important, if you're doing a power of attorney, to really have a conversation with the attorney as to all of the ramifications, if something is initialed, is not initialed, because the asset protection planning that we do utilizing a power of attorney needs to have specific areas initialed, such as in the modifications. We need the power to be able to gift assets and or to create trusts, whether it be an irrevocable trust or a revocable trust. The modification section, goes through what's called spousal refusal, Medicaid applications. We're going to briefly touch on Medicaid, because in the conversation about protecting assets, we need to really understand the concept of what we're protecting from and what is the Medicaid program and what are the thresholds. A last will and testament, I think, is just always very important to discuss, because it is, I would say, probably the most commonly known estate planning document. You see movies all of the time where there's the reading of the will, or somebody, left someone out of the will. And whenever we do pro bono consultations at events, I'd say it's one of the most popular questions is, should I have a will? Should I put this in a will? So really, a last will and testament is a document that allows you to put in writing, when you're of sound mind, who you want to receive what from your estate. So it's very important to understand that your last will really is only controlled by assets in your name alone at the time of your passing that didn't have a joint account owner and or a named beneficiary. So I have a Chase Bank account, it is joint with my husband. Upon my passing, if it's joint with right of survivorship, my husband gets access to those monies by what's called right of survivorship. My will does not need to be probated or entered into the surrogate's court in order for him to get access to those funds. If that Chase account was in my name alone, upon my passing, the account's basically frozen. Once Chase learns of my passing, nobody can access or utilize those monies until they get what are called letters testamentary or letters of administration. So it's a very popular misconception that when you do a will, you're giving the what's called the executor, which that's the person that you're appointing or nominating to handle your estate, authority. And unfortunately, that's not true. Your will is going to include the beneficiaries, right? So people, charities, other entities, pets. Who is it that's going to be receiving your assets? What type of assets are you going to be distributing in this last will and testament? Is it your personal property? Is it specific bequests? Meaning, are you giving certain percentages of your assets, certain dollar amounts to people or charities? Are you giving and disposing away of your real property, cooperative apartments? And then there's the residuary estate. That's basically what remains after all of those other specific, or sorry, someone keeps popping up that I keep trying to admit, but I don't know if they're coming in. Sorry about that. The fiduciaries, so those are the individuals, the executor and the trustee. So the executor is the individual or more than one that you've appointed to handle the estate. So upon your passing, you have an asset in your name alone, whether it be your home, a bank account that did not name a beneficiary and did not have a joint account owner. The individual you've nominated to be the executor is the one that's going to have to file your will for probate in the surrogate's court. So I pass away and I reside in Westchester. My will is being probated in the Westchester County Surrogate's Court. A probate petition is basically going to be filed by the fiduciary that I've nominated. So by my passing, the individual I've nominated or named as the executor has no authority until the court recognizes my will, right? So my original will is filed with a petition with a filing fee. So it's a process. We avoid probate and we do asset protection planning utilizing trusts. So that's what we're going to kind of dive into next. I always like to kind of touch on what happens if you pass without a will, because this is another, I would say, big misconception area. A lot of times when meeting with somebody, they'll say, well, I need to get a will done. I'm going on vacation and I don't want something to happen and the state takes all of my assets. The state's not going to come in and take your assets if you don't have a last will and testament. If you don't have a last will and testament upon passing, and again, you have assets in your name alone that we would look to the will for, you're going to, the individual, the next of kin surviving, is going to do what's called an administration proceeding. And your assets are going to pass pursuant to the laws of intestacy. What that means is we're looking to a statutory scheme, basically to your heirs. Who is the next surviving kin who should receive your assets? So it's very important for you to do a last will and testament if you don't want any chance of a next surviving heir to receive your assets. So let's say you have 3 children and there's one child you're estranged and you don't want them to receive any assets. Very important that you either do planning to avoid probate, or you do a will and you make sure to intentionally not leave anything to that individual, right? Because if you don't do a will, but your strong wish is that one of your children does not receive anything, if you pass away with no documentation of a last will and testament to guide the court is bound by the laws of intestacy and everything's going to go a third, a third, a third. So, you know, when meeting with an elder law attorney, it's just very important to have that confidential conversation as to the family dynamic, as to your wishes, and as to really what your goals are. Are your goals to avoid probating of the will and to transfer assets out of your name to engage in asset preservation? Or is it to keep everything kind of available to you and not trying to do any of that long-term planning? So probate avoidance can be done in a few different ways. The ones we're going to focus on are the revocable and the irrevocable trust. So the revocable trust is not what we would reference as an asset preservation vehicle. That's because this is the type of trust that you create while you are alive. You are what's called the grantor, the creator, and most commonly you are also the trustee. We have done, revocable trust where, the grantor, meaning, let's say it's the Samantha Lyons Revocable Trust. I'm the grantor and a trustee, and my husband's a co-trustee. I have to sign and create this trust, and then I have to actually transfer the assets to the trust. Simply by signing a trust, my assets are not retitled. I have to go to a bank and physically open a new bank account in the name of my trust and transfer the monies or deed my property to the trust. By signing it, you just have the vehicle, but you actually have to fund it with your assets. The revocable trust is fully available to me as the grantor. What does that mean? If I were to need Medicaid, any assets titled to my revocable trust are available for my eligibility. Medicaid in New York is a financial means tested program. So there are certain thresholds that we're going to discuss that I need to be below in order to qualify. The threshold is $16,800 in non-retirement liquid assets. So if I have a revocable trust and I have a Chase Bank account with $150,000 in it, if I apply for Medicaid, I'm going to be denied because I'm above the threshold and the assets in the trust are available to me and to my Medicaid eligibility. So it's a great vehicle and tool for avoiding probate. Upon my passing, the assets that I've titled to the revocable trust are going to go to the named beneficiaries. So it's similar to if you have a payable on death or POD account, where the beneficiaries are going to go to the bank account, the financial institution, and provide a copy of the death certificate to basically demonstrate that they are the ones entitled to the assets and court intervention is not needed. One of the nice things about the revocable trust and why some individuals choose to do this rather than just, naming children, let's say, as the beneficiaries on their bank account, is you have a lot more control in regards to the beneficiaries. So you can have trust set up within your trust, where if, let's say, God forbid, a child predeceases you and now their share is going to their children, being your grandchildren, you can have the money held in a trust until that grandchild attains a certain age. So with the bank, it's usually just payable to the beneficiary upon your passing. You can have it structured many different ways in the revocable and the irrevocable trust that we'll discuss. But yeah, so takeaway on the revocable is it's not utilized as an asset protection tool. The irrevocable trust, irrevocable trust, is also known as what we call a Medicaid asset protection trust. So creating this trust is a great vehicle to do asset preservation and protect your assets against the cost of long-term care. So you are the creator, which is same the grantor, but you cannot be a trustee of your irrevocable Medicaid trust. You have to appoint other individuals to be the trustee, either one or numerous. You are not allowed direct access to the principal of the trust, or what we call the corpus. So if I put that $150,000 account into my irrevocable trust, I no longer own it. The way the trust is structured from a tax standpoint, it's still taxable to me. It's not a completed gift for tax purposes until I pass. But from a Medicaid standpoint, that $150,000 does not count against my eligibility. So that sounds great, but I disqualify myself and my spouse for 5 years by transferring assets to an irrevocable trust for nursing home Medicaid. There's currently no look back for home care Medicaid. So there's two programs. Home care Medicaid is you residing in the community, whether it be in your home, an apartment, an assisted living facility, wherever you consider to be your primary residence, and receiving coverage from New York State Medicaid for home care attendance. So an individual to assist you in the community with what are called your activities of daily living, or ADLs. Governor Cuomo had passed a look back, which is to be 2.5 years, retroactive as of right now, if it were to be implemented, to October of 2020. The implementation has continually been delayed due to the extension of the public health emergency. So we cannot have any changes or harm done in the Medicaid world until the public health emergency ends. The most recent thought as of this week is that it's potentially not going to be implemented until 2024, due to just all of the documentation, red tape that would need to come along with the end of the public health emergency and the deadlines to get all of the approvals for the implementation. So basically the takeaway is that as of today, there is no look back for home care Medicaid. So I can have assets above the threshold of $16,800 and transfer my surplus monies to an irrevocable asset trust and have no penalty to get home care Medicaid. There is the 5-year or 60-month look back. So this is the 5-year look back, I'd say, is kind of a buzzword that most people have heard of if they've looked into Medicaid. It only applies when you're seeking coverage of the room and board in a skilled nursing facility. So if I needed nursing home Medicaid or coverage of my room and board, I either private pay it, which we'll see there's a slide that kind of goes through the average cost of a nursing home. It's very expensive. Or I can become eligible for nursing home Medicaid. I need to provide mine and my spouse's past 5 years of financial records, so all of my account statements, and Medicaid's going to look for any transfers of assets to basically incur a penalty period. So the funding of my irrevocable trust, because remember, just like the revocable, I create the vehicle by signing the trust and appointing trustees, but my assets are not automatically transferred. I have to decide what assets, non-retirement, so checking, savings, investment accounts, property, vacation homes, I want to put into this irrevocable trust to start the asset protection, to get the assets out of my name and either apply for the home care Medicaid program or not look to the nursing home Medicaid program for at least 5 years. So, kind of the benefits were on the prior slide, the detriments. Really the biggest detriment is that you are disqualifying you and your spouse for nursing home Medicaid. So we don't do irrevocable asset protection planning. If someone comes to us and says, my loved one, my spouse is in a rehab and I think they're going to be staying long-term in a nursing home, that's not the time to be doing asset protection planning. There's certain, conversations to be had for the spouse that is not in need of the coverage to do what is called post-eligibility planning, but that is transferring assets once the sick spouse who is in need of the nursing home coverage is approved for the nursing home Medicaid and then 30 days has passed. So it's a process. I mean, there is a lot of ways to qualify an individual for nursing home Medicaid. But if they've transferred assets in the past 5 years, that needs to be dealt with, whether it be going to what's called a Medicaid fair hearing to demonstrate to an administrative law judge, I didn't transfer those assets to qualify for Medicaid, but it was my pattern over the past 10 years of giving X amount of dollars to my children or my grandchildren, or I promised to pay for college. And, doing so did not diminish any of my assets. And I was not in any contemplation of needing nursing home care at this time. That's an avenue. Or monies can be returned that were previously gifted. There are certain mechanisms in the asset protection trust to allow for trustees to get assets back out. Should you, God forbid, need the nursing home coverage before the 5 years has elapsed, you can gain the same protection of assets and start of the 5-year look back by getting assets out of your name via outright transfers. Meaning, if I give money to my child and I give money to my asset protection trust, it's the same disqualification. It's the same 5-year look back where I wouldn't apply either before returning those monies or 5 years has elapsed. The reason why I don't love and or recommend outright transfers to children or loved ones is that you make the transfer, let's say today. You're of pretty good health, you're not contemplating needing nursing home care, but you want to start some protection on your assets. You get monies out of your name and you divide it among your children and maybe some, accounts for grandchildren. 3 years from now, maybe there is an unexpected fall, a surgery, a stroke, and you are in now need of coverage in a skilled nursing facility. Well, if your family member came to consult with us, we'd want to know, well, where is the money that's been transferred? How much can we get back to your name to then discuss and do what is called a Medicaid crisis plan? So I know there's a lot of terminology being thrown at you guys today. But the problem is that if I now know that you've given monies to all different parties, there's no guarantee that those individuals have held on to the money, right? You've given it to them. They could have easily spent it. They could have done renovations to their home, a new roof, a driveway. Now that money is lost in the Medicaid world. I can't get it back. And we're going to have to discuss the other avenues to take it as a gift or go to a fair hearing. When we put it in a vehicle such as the Asset Protection Trust, we know exactly where it is, right? You may not have the direct access to make the withdrawals of the money to yourself, but you can get copies of the account statements. If the trustees are doing something funky or using the monies inappropriately or for themselves, you remain to have the power to remove those trustees and or change your beneficiaries. There's also creditor protection. If you're giving money to your children, God forbid that child gets in a car accident, the money you've given them is now their personal money sitting in their bank account. So they're sued, that's potentially going to be available against their creditor. You put it into your irrevocable trust, they're a trustee, that money is not available personally to them. So, there's a lot of different conversations and caveats to kind of parcel through. Maybe one of your children is going to be applying for financial aid for a grandchild to apply for college, or, you know, any other form of higher education. If you're gifting them this money, that may disqualify anyone for financial aid. So there's just a lot of different things that we want to go through, maybe in the consultation or a document review, as to kind of your own personal needs and really the individuals you're involving in your estate plan as well. The cost of long-term care. So I know I discussed that, you know, the very expensive cost, and I'd say these amounts are a little bit on the lower of what we're starting to see more frequently. Nursing home care, you know, you're looking at definitely over $100,000 a year for someone who is in long-term skilled nursing. It's usually a daily rate that the facility will bill a month in advance. Home care, I see range from $20 to $45 an hour, really depending on the type of agency and the type of care that you or the loved one is in need of. But if you're paying $21 an hour, you need 8 hours of care 7 days a week, that's over $60,000 a year, right? So this money that you saved and now that you're potentially living off of will go very, very quickly if you were to completely private pay for your care. So limiting the cost of care is doing the long-term asset protection planning by getting assets out of your name to individuals such as your children, doing irrevocable trust, setting up, you know, I didn't really discuss it, but you can do a children's trust where it's an irrevocable trust, but it's for the benefit of a child or a grandchild, and you're putting the money into that trust. You can't then take it back. Getting the asset out of your name that's disqualifying you for nursing home Medicaid for 5 years. Long-term care insurance is, you know, a tool that can be utilized to help reduce the cost of your care. You're utilizing your policy to either pay for the care directly or reimburse you, or Medicaid. So what I want to kind of now dive into is in terms of protecting assets. Right, we're protecting from the cost of Medicaid, but it's also very important to be aware of all of the scams that are out there and kind of elder abuse, right? Unfortunately, over the past 2 years, the amount of abuse and scams that we're seeing is insane. I mean, there's a lot of very, I don't want to say well done, but we're going to discuss kind of these lottery schemes where individuals are receiving New York lottery tickets that look very real, and someone who may be of more diminished capacity or living alone is going to potentially fall for it and then be embarrassed to call the police, let a loved one know. And it's kind of this vicious cycle of spending down their assets and or letting someone gain access to their assets. So I think this is just very important to kind of hash through. You know, who we see is kind of most at risk for becoming a victim of elder abuse, and, you know, basically allowing someone access directly to their finances is someone who may have a cognitive impairment, whether it be dementia or Alzheimer's. Social isolation played a huge part, especially during quarantines and COVID. Domestic violence, shared living arrangements, and when we have kind of the web of dependency. So we had a parent who is maybe living by themselves and is very dependent on the child or the sibling to be their caretaker, to get them their groceries, to go to the bank for them. It's very easier for the abuser, if they know that they're being dependent on, to take advantage. Warning signs to look for in kind of a loved one is, you know, from a physical standpoint, it's hygiene, injuries, bruises, you know, not being able to explain certain things. Social is when we're seeing distress, anxiety, someone becoming more withdrawn. Financial, you know, sometimes the banks are the first one to pick up on this because someone has had such a routine of spending and now all of a sudden there's a huge change in their financial condition. They're withdrawing large sums of money they're not paying certain bills, and they just start to act a little out of character. These are there's a few different scams that we're going to briefly go through. I also want to make sure we have time for questions at the end. The distracting hook, a con artist, and then what we call the deadline. I like to put in this slide just so you're aware of the available resources that are very important if you may be concerned about a neighbor, a loved one. I mean, it's always very important to speak up, right? You know, the old NYPD, see something, say something. We have the Attorney General's office, your local police station, maybe the local bank, adult protective services. You can make anonymous complaints. And then there's the Westchester County District Attorney Elder Abuse Division. The distracting hook, I'd say, has been one of the more popular, especially during quarantine and COVID, right? Isolation, loneliness, boredom. Now something is grabbing your attention and it's appealing to you, where you may have already been vulnerable and let your guard down, or it's allowing you to further let your guard down. Usually pertaining to money, you know, the promise of suddenly coming into funds, helping a loved one. You know, we're going to discuss the grandparent scam, you know, has been a horrible scam that we've seen in Westchester County. And fear and desperation, you know, making idle threats to basically further isolate or leave someone on their own. The con artist, so, you know, as stated in the slide, most people are going to be more trustworthy unless given a reason not to. Yes, there are definitely individuals out there who do not trust anyone, but scammers become very good at kind of reading the person and finding the best way to manipulate and then take advantage of the financial resources. Deadline, that's basically just telling the individual, you know, you got to do it now because it's not going to be an option for you tomorrow. Usually anytime someone is telling you that, especially if they're claiming to be from a governmental agency or your electric company, it's not legitimate. The most common, especially the ones that we've seen are the sweepstakes contests, the grandparent scam, the home improvement, IRS, investment, identity theft. I mean, it's really, you know, not only can you protect yourself by having the advanced directives, the power of attorney set up for someone to assist you financially, but looking into kind of LifeLock or the Experian Equifax lock on your credit to kind of be alerted anytime there is a change. You know, if your email is on the dark web, if anyone's hacked into an account, if anyone's opened an account that you weren't aware of, kind of puts you one step ahead. Because unfortunately, you know, the internet and the web is a very, very great place, but scary place in the sense of what individuals are really able to do. Some examples of the sweepstakes or contest scams is, you know, you are the millionth customer, you won the cruise, you won some money. If you just send us the $100 via your bank, well, then wire you the rest of the funds. Unfortunately, someone of diminished capacity is going to fall into this more easily. They have a bank account in their name alone, so no one is really aware of anything, you know, fishy or different than going on. There may be no power of attorney on the account to monitor what's going on or put a stop to anything. And then, you know, it becomes a game to the scammer. We've had scammers showing up to individuals' homes to basically deliver the winnings and kind of entice with, well, if you just send us $200 more, we'll come back next week with even more money. And it's horrible, you know, just how taken advantage individuals can become, especially when they're isolated and or suffering from dementia, diminished capacity. And then there's shame. You don't want to tell anyone, you don't want a loved one to know what mistakes you've made or who you may have trusted. basically never wire money to anybody that you don't know. You never are going to have to pay to collect any prize, right? If you've won a prize, you've won a prize. You don't need to pay a fee or give your bank account information to receive. And the craziest thing is really don't rely on your caller ID. I mean, these hackers have become so good that, there's been big IRS or Con Ed, NYSEG scams, and the caller ID will say Internal Revenue Service. And, clients have said, well, it said IRS. So when I answered, I was already under the impression that this couldn't be a scam because the caller ID told me who it was. I think the IRS has put out basically that they're not going to be calling you to be requesting funds. Social Security is not going to be calling you to ask for your Social Security number over the phone. Grandparent Scam was really big a while back. We still hear stories about people, getting this type of call. It's basically a very urgent call from, your favorite grandchild, and they may have a very muffled sound. They're going to say that they're in jail, they've been punched in the face. That's why their voice sounds funny. Their nose is broken. They need to get the money immediately to either pay off this person who's harming them, to bail them out of jail. And unfortunately, it happens a lot where somebody is panicked because they think that this loved one is in danger and they don't want to, they've been told not to tell the other family members. Don't send money to anyone calling you over the phone. Again, don't wire funds to anybody that you do not know. Always try and get any contact information of somebody who's called to try and verify and or have their information once you have determined that it's a scam. Follow up with the family member, or even, we have some individuals who developed basically code words, right? I mean, when I was in high school, my mom gave me a word where if I was somewhere and I was uncomfortable, I called and said the word. And even if I was saying something differently on the phone, she knew that meant I didn't want to be somewhere. Have the code word where if there's ever an urgent issue, you can either ask, well, what's the code? Or they can slip it in. And if they don't know it, then, you're not dealing with this loved one of yours. So home improvement, this is basically someone perusing the neighborhood. Someone's coming, they're doing basically, they're passing by, they notice that you may need some trees down, you may need your roof, to be fixed, and they're trying to take advantage of someone, right? Unfortunately, here's kind of a little cheat sheet that we like to give out to basically avoid the scam. Another reason why I really highly encourage the power of attorney is that, if you or the loved one can't handle these decisions, they're going to defer and or tell this contractor or someone to speak to you, and you as the agent, or the person you've appointed as the agent is going to have full authority to be able to have these conversations and sign documents on your behalf. The IRS phone scams I briefly touched on. It's basically someone impersonating the IRS and unfortunately having on their caller ID that they're calling from the Internal Revenue System. Never, ever give out your personal information over the phone, being your Social Security number, your bank account and routing number to have funds wired, and report anything that may be funky, right? I've had clients tell me that they've had a lot of missed calls that say IRS and they're nervous. They don't want to call back because they're not sure if it's real. Usually, we're going to recommend that you do not call back. You're going to report it to, the Inspector General. You can call the IRS directly from their published numbers to find out if there is any issues of you owing any back taxes or penalties, etc. Investment scams. So it's great to do the asset protection planning to put your assets, being really your non-retirement monies, into an irrevocable trust. That's going to allow, though, your trustees, and why it's very important that you have individuals that you trust as your trustees, being the ones to manage, invest, and reinvest the funds. We don't want your trustees getting involved in any type of Ponzi or pyramid scheme, lending schemes with the assets that you're aiming to protect within your trust. So kind of, and going back to the conversation of the asset protection trust, who do you select as your trustee? You know, it's the same as the power of attorney. We want someone who you're going to trust, who you do not have an issue managing and handling your financial affairs for you, and not allowing for maybe your neighbor who you've had a close relationship with, but you don't know all of their maybe personal details, right? If they are in need of any funds and may start borrowing money from the trust because they have access with the, hope that they're going to repay you. It's just very important that you don't give this broad authority that we discussed and that I recommend to somebody that you may not trust fully, right? A lot of times the conversation that we're going to have with a client is maybe they're single, they were never married, or they're widowed, divorced, never had children. Who are they going to appoint as the agent under their power of attorney, as the executor on their last will and testament, if they don't really have someone that they implicitly, want to hand all of their finances over to? So that's when really the conversation of corporate trustees, banks, there's certain agencies where there are fiduciaries, where basically they are the perfect person to look to in this situation. They don't have any vested interest in your finances, but they're a trained professional, either in the financial world or, an accountant, and they're willing to basically take on the duty of being the fiduciary to honor your best wishes. Tips to maximize your safety on the internet and to protect your assets. It's kind of hand in hand, especially in today's world with everything really being electronic, right? I think the majority of individuals pay their bills online, set up all their accounts online. I do still utilize a checkbook. I think a lot of my older clients do as well, but it is very convenient to have everything set up on auto pay. Just make sure you check your accounts, make sure to check your credit reports, do some of those locking systems. Create very strong passwords. I mean, a lot of the things now, you have to put in an asterisk, a number, a capital, a lowercase. Don't use the same password on all of your accounts. Always make sure you're looking that you're on a secure site. It's going to have that little S, the HTTPS. There's the security certificate to look for, privacy settings, on social networking. Don't post pictures of any of your personal information. It's crazy sometimes when you see someone who's posted a picture where it's a very innocent picture in their home of maybe a family member, but if you easily screenshot or zoom in, you get a lot of information from a photo. You can get a lot of information on a social media website. If you have your birthday listed, someone can try and get into your bank accounts by answering your security questions, right? A lot of stuff is available on white pages, potentially your maiden name, your mother's name. So very important to try and make everything as secure as you can, to constantly change your passwords. Don't give out any of your personal information. Don't wire money, other than maybe dealing with your direct financial institution. It's become a huge issue, I'd say in law firms. They're getting hackers sending emails to basically, we're scheduled for the closing tomorrow, please wire funds below. And they've gotten so good that they're hacking into your computer. They're seeing who you've been corresponding with, and then they're creating an email that's one letter off. So, in your quick, busy day, you have this closing coming up, and you see the email, you're not looking at the full name, right? It's someone you've recognized, but it's actually a hacker looking to basically get in and take the funds, drain your bank accounts. This is kind of just a summary. Don't carry your social security card with you. I know it's very, very common. Every time, I'm sitting down with a client and we're going through their assets for Medicaid purposes, they'll always take out their social security card and hand it to me. Make sure you try and shred all of your bank account statements. It's recommended if you receive the paper copies, you keep them for 7 years. Don't just throw everything in the garbage. It's very easy for someone to go through your garbage, get all more personal information, to hack into your personal accounts, and just, have the conversation, sit down with an attorney. I would recommend an elder law attorney. Trust and estates attorney is great as well, but you just want, when you're having a discussion about asset protection, making sure you have a plan set up where you're either doing the Medicaid planning, getting assets out of your name, you're putting everything kind of in one place, so the loved one or family member that you've designated to be your agent or be your proxy knows where everything is. Have an open and honest conversation. It only helps me when a client tells me kind of the full picture. A lot of times I sit down with someone and they're telling me, a little bit about the family history, and then the more we're working together, the more stuff is coming out, and maybe the initial conversation and recommendations would have been different in the discussion of the power of attorney and the trustees had we known really the full story. So very important to give kind of the full screenshot, not only your full assets, your full income when discussing a plan for you, but also kind of the family dynamic.